Watching Newslink on ENCA. My name is Annika Larsen. Well, with former President Jacob Zuma behind bars for now, where does that leave the High Court application to interdict his arrest and the Constitutional Court rescission matter? And what does former President Zuma's detention mean? Well, let's bring in legal analyst attorney Sinawo Makangela. Sinawo, thank you so much for speaking to us this morning. Let's start. Is the High Court interdict, judgments expected tomorrow, is that now moot?
Thank you, Annika, and thank you to the viewers. Actually, now I think there's an obligation to all the legal practitioners involved in the matter to write a letter today to the judge and advise him that the order that he wanted to interdict has been executed, so that when the judge tomorrow delivers his judgment, he's aware of the developments, the latest developments from the day the matter was heard and until to date. So that means when the judgment comes tomorrow, it has been overtaken by events. There are no longer live issues now. So the matter is moot now.
Okay, so that's interesting. The parties will have to write to the judge hearing the matter at the Pietermaritzburg High Court and advise him of the fact that the applicant is now incarcerated. Moving on to the rescission matter to be heard on Monday, what will be the process there as far as you could understand?
Well, there's nothing that changes. As we all know that in our law, that rescission does not suspend the operation of the order. So nothing has changed. The matter will be heard on Monday. It's up now to the Court to see if, in terms of the test, whether the applicant, that is now the former president, has made out a case for the rescission of his order that caused him.
Sinawo, this isn't a criminal matter per se, in terms of there was no trial. Could the former president's lawyers make an urgent bail application today, or some kind of application for a stay of the execution of the warrant, or give him more time, before Monday so that he can consult with his legal team?
Well, Annika, that was done. The application was meant to stay the execution of the order. Remember, bail application would only be available if somebody is appealing the judgment. As we say in our legal system, there are those options where the convicted person can apply for a bail pending an appeal. But as we are saying, in this case, it's not an appeal. It's a rescission. So a rescission then it's regulated by the rules of the Constitutional Court, as you might have seen that in the papers of the former president. So there's no such a thing as called bail. The point is now Judge Mnguni of Pietermaritzburg is aware that there is an order. There is an order that ought to have been executed by the members of the South African Police Services. So the reason why the former president ran the court was he wanted to stay the execution of that order. And the police officials were duty bound to execute the order, and they have executed the order. Now there is nothing else. As I say, the practitioners, they just have an obligation just to let the judge know that actually what he wanted you to do has now been overtaken by events. Whatever decisions that you'll be bringing tomorrow, you must now know that the former president has been incarcerated, is in jail now, meaning the order has been executed already.
All right, thank you so much there for that analysis from attorney Sinawo Makangela. He says that the urgent interdict that was applied for earlier this week is now moot. It was to stay the arrest of Jacob Zuma, but he is incarcerated, and therefore the legal parties will have to write to the court and advise him of this fact.